Welcome to our first video in this series about the criminal case process. And today's going to be all about the arraignment. Now, arraignment is just a fancy word for your first day in court. So if you've been charged with a crime and you need to go to court for your arraignment, gonna want to stay tuned to learn just where you need to go, what you need to do when you get there, and what's going to happen to you at the arraignment. All right, so you got to court on the day of your arraignment. Hopefully, you got there nice and early because there's a couple of things you're going to need to do before you can go into the courtroom and they're going to call your case. And the very first thing you should do when you get to court is to go to the probation department to check in. Now, the probation department has two very important functions that they perform on the day of an arraignment. The first is to pull your criminal record. The second is to get some financial information from you so they can decide whether or not you might qualify for a court appointed or free lawyer. Okay, let's talk about each of those individually. First is the probation officer is going to ask you some basic questions like your name, your date of birth, where do you live, social security number. They might ask you to produce an ID. And this is so that they can run your criminal record. Now, if you don't have a criminal record, they still have to check that by running it, and they'll let the court know you have no prior criminal record. Okay. But if you do have a record, they're going to print out a copy of that. They're going to bring it into the courtroom. The judge is going to get a copy. Your lawyer is going to get a copy, and so is the DA. And they're going to use that criminal record to help make decisions about what to do with you while this case is going on or while this case is pending. Okay. The second function of the probation department is to get some financial information from you. And that's so that they can see if you might qualify for a court appointed or practically free lawyer. Okay. Sometimes, depending on where you fit on the financial scale, you might have to pay something towards that representation. A one-time nominal fee, usually about $150, sometimes as much as $300 to help pay for that, but it's a one-time fee. And so they can ask you a bunch of questions like, are you working? Where do you work? How much money do you make? How big is your family? Do you own your home or do you rent your home? Do you receive any type of public assistance? And if so, they're going to want you to try to prove that in some way through letters and things like that. And like I said, they're doing all of this to decide whether or not you would qualify for a court appointed lawyer that's paid for by the state. Okay. And so it's really important that you don't skip this trip to probation. And here's why. Because they're not going to call your case in court until you've done that check on the probation and probation's been able to complete those functions. Okay. So if you skip the trip to probation, you're just going to be sitting around all day waiting for your case to be called, and it's not going to happen. So it's really important. The first thing you need to do when you get to court is to go to the probation department and do that check in. All right, so you finished your check-in with probation, and they should have told you which courtroom to go in to wait for your case to be called. Now, if you hired a lawyer, this is a good opportunity to go find that lawyer and ask any last-minute questions you might have, such as, hey, what do I do when my name is called? Where do I go? Where do I stand? Do I say anything? It's also a good opportunity to talk to them a little bit more about the case. At this point, your lawyer may have received some additional information from the court about your case. They likely would have gotten the criminal complaint as well as a police report, which can have important details about the case. And this is a good time to go over those questions with them. All right. You may be at a little bit of a disadvantage if you didn't hire a lawyer and you have a court appointed lawyer because you likely would not have been introduced to the person at this time. But if you have any basic questions, such as, like I said before, where to stand, where to go when your name is called, stuff like that, you should feel free to ask any of the court staff, like the court officers or the court clerks. They're going to be more than happy to help you if you just go up and ask them politely. If all else fails, just follow this quick little tip about where to go when your name is called. Now, it goes something like this. Chances are you're not going to be the first case to be called that day. So what you do as you're waiting for your name to be called is you just watch. Watch what the other people do, see where they go stand, and just do what they did. All right, so now's the moment of truth. You've been to probation, you checked in, you went to the courtroom. Hopefully, you got to speak with your lawyer and went over what's going to happen, where you need to stand, what you need to do. And now the judge is coming on the bench, and eventually your name gets called. You go to where you're supposed to stand, and what happens next? This is where the clerk would normally read what the charges are to you, to formally advise you what you're being charged with. Now, as a practical thing, most lawyers will actually waive this formal reading of the charges. And this is for a couple of different reasons. One, you already know what you've been charged with. The police probably told you, they might have given you some paperwork. You might have received a notice in the mail. But certainly your lawyer who's received the actual criminal complaint with the charges on it, as well as a police report, would have gone over that with you, and you know what you're being charged with. So that's one reason they might waive the reading of the charges. Another is just to protect your privacy to a certain extent. A quorum is a public forum where everyone gets to go and watch everyone else. And just by not having them read those charges out loud, it protects your privacy just a little bit. And after they read the charges, what happens is they automatically enter a plea of not guilty on your behalf. You don't have to do anything. You don't have to say anything. This is automatic. All right, so now you've been formally arraigned. What happens next? This is typically where the judge is going to turn to the prosecutor and ask if they have any requests. And these are requests for what to do with you while this case is going on, while this case is pending. And there's basically four things that could potentially happen, or it could be a combination of these things depending on the circumstances. And the first is you could be released on what they call personal recognizance, which is just your promise to come back to court as required and not necessarily have to do anything else. Okay. It's just your promise. They trust you to come back, maybe because you have no prior record, maybe because the case isn't so serious. It could be any particular reason for that, but it's actually the most common thing that people get at this stage. The second thing that the prosecutor could ask for is cash bail. And this is just money that you place with the court to ensure you're going to come back. Think of it like a security deposit. Okay. And basically, as long as you come back to court as you're supposed to, then you're going to get that money back at the end, even if you lose the case. It doesn't matter if you win the case or you lose the case. As long as you've been coming to court as you're supposed to, at the end, you're going to get that cash bail back. And the third thing they could do is set conditions of release. And what this means is the court tells you to do something or not do something while you're out in the community. And this has to be related to the particular case. So, an example of this might be, let's say it's an assault and battery case. They might tell you to stay away from a particular person or a particular place who's involved in the case. Or let's just say it's a drug or alcohol case. They might tell you they don't want you to drink any alcohol or take any drugs during this period of time, and that you might have to submit to random screens to verify that you're doing those things. These are just a couple of types of conditions that the court might set against you. And like I said, they all have to be reasonably related to the incident that brought us here in the first place. And those are certain types of conditions. And the other thing that the prosecutor could ask for is that you be held without bail, meaning that you're not going home. You're going to the jail to be held there without bail for a certain period of time. Now, this is definitely more rare. It usually only occurs in circumstances involving violent felonies. So it's definitely more rare, not the normal situation for a person. Now, keep in mind that these are the four things prosecutors could ask for, and they could ask for, one or any combination of them. So, for instance, they might ask for, all right, let's let them go on personal recognizance, but I want a condition that you stay away from this particular place. Or they might say, hey, we're asking for cash bail to be posted and also a condition to be put in place. Now, just because the prosecutor asks for these things, it doesn't mean they get these things. This is where your lawyer steps in, and your lawyer has to argue on your behalf as to why a particular thing, or whether it's bail or a particular condition, doesn't make sense for the circumstances or is not needed under the circumstances, and your lawyer can advocate on your behalf. Now, what they usually do is they take into account you, right? What's your personal history like? Um, are you working? Are you married? Do you have kids? Do you have a prior criminal record? If you do, how bad is it? How old is it? Do you have a history of not coming back to court and defaulting on your court obligations? These are all factors that they might take into account to decide exactly what to do with you. Is bail necessary? Are conditions necessary? Or can we just trust you to come back on your own? This is where your lawyer will argue on your behalf to get you the least restrictive conditions or the least amount of bail possible. And in the case of the prosecutor's asking for no bail, to try to keep you, to try to admit you to some kind of bail or conditions to make sure you're not sitting in jail while this case is going on. Now, in all of these cases, it's still up to the judge to decide what to do. The prosecutor makes their request, your lawyer makes the argument on your behalf as to what they think is appropriate, and the judge has to make the decision as to what to do with you while this case is going on. All right, so now you've been arraigned. The judge has decided what they're going to do with you while this case is going on. Maybe they set bail, maybe they set conditions of release. So, what happens next? It's usually at this point that the clerk gives you what we refer to as a bail warning. And a bail warning is the clerk telling you that if you pick up any other charges while this case is going on, the court could hold you in custody for up to 90 days. All right. So basically, what they're telling you is stay out of trouble. Don't pick up any other charges, or else after a hearing, the judge might decide that you're not following the rules and we need to stick you in jail for up to 90 days or until this case has been resolved. All right. That happens in every single case. There's no arguing against it. You're going to get that bail warning, and it's best to listen to that bail warning and make sure you pick up no other charges and stay out of trouble while the case is going on. And after that, the court's going to look to your lawyer to ask them to select the next hearing date. And we call that a pretrial hearing. That date's going to be, typically speaking, about 4 to 6 weeks from the date of the arraignment. Now, that's just a guideline. It's going to depend on a number of factors, including your lawyer's schedule as well as the court's schedule. But 4 to 6 weeks is pretty typical. And many courts will allow you to appear via Zoom for these hearings, or maybe allow your lawyer to waive your appearance altogether. This is so as to not inconvenience you, so you don't have to lose more time from work, possibly, or if you have kids you got to watch or something like that, so as not to disrupt your life too much. Because oftentimes at the pretrial hearings, just the lawyers talking about what's happening in the case, and your input isn't always really required or needed. So some courts will allow you to appear virtually or not appear at all, depending on the circumstances. But that's going to vary court to court. You really want to speak to your lawyer about that to see if that's allowed in the court that you're in, and that's something that you want to do. All right. So to learn more about this pretrial hearing date or this second day in court, stay tuned to the next video in our series, which will be all about the pretrial hearing date.